I'm Colin O'Keefe, and this is LXBN TV. California Governor Jerry Brown recently signed into law two major changes to California's online privacy laws. The changes regarding data breach notifications and do not track disclosures have the potential to set a trend for the rest of the country. Joining me now to explain the laws and their potential impact is Tanya Forsythe of Info Law Group and also author on an excellent blog of the same name. Tanya, first, can you describe the major changes to California's online privacy laws? As I understand it, there are two major ones here.
Right, absolutely. Thanks for having me today, Colin. So we do have two fairly significant changes to California law. The first is an amendment to the existing California Online Privacy Protection Act, which is commonly known as AB 370. That's the bill that everybody's been talking about. And it's essentially a do not track disclosure law. It's very short. It only adds a few paragraphs to the existing law, which is the one that requires a privacy policy. And it essentially says that if an operator of a website or an online service is using or is collecting information about a user as they travel across the web and across time, that there needs to be a disclosure as to whether that operator is honoring things like a do not track signal. And then there's this interesting language that says, or other mechanisms in the law, other mechanisms about a customer's, with respect to tracking a customer's online activity. So it's certainly not entirely clear what the law means and how it's going to be interpreted going forward, how the California Attorney General will interpret it. There's another piece of it that also requires a disclosure as to whether the operator is allowing third parties to collect a consumer's information on the website, and that's a yes or no disclosure. So even if the operator is not doing that, they need to say they're not doing that. They're not allowing third parties to do that. One question that's come up is whether people really know, whether companies really know all the third parties that are out there doing things on their websites and collecting information. So it's a big change. And the other one, as you mentioned, is the data breach law change, which adds a username and password to the data elements, or email address or username with a password to the data elements that could trigger a breach notification requirement. Also, for example, a security answer and question and answer could also, a username with a security answer and question. So that's a very big change to data breach notification law and could very well cause a trend around the rest of the country, as happened with California's original breach notification law.
I see. So segging off that, you wrote in your own post on this story that this could potentially be a new era for privacy law, both inside and out of California. So can you explain, just how impactful are these laws going to be, both inside and out of the Golden State?
Right. Well, I can tell you, having just come back from the big IAPP conference, which is the International Association of Privacy Professionals, that everyone is talking about AB 370, the do not track disclosure. It's having a significant impact, if only at this point because people are trying to figure out the best way to comply and what it means, especially because ongoing discussions, industry discussions about what do not track really means or what do not track should mean, the substance of it, right? Not just whether somebody honors a signal, but what does it actually mean to honor a do not track signal? Does it mean you don't collect information? Does it mean you don't serve a person with behavioral advertising? There's a lot of dispute, even within industry, and then, of course, with regulators and advocates. So the impact is this is causing a lot of initial discussion. What does it mean? How are we going to comply? And really, what's the future of do not track? None of us know at this time, but I think it would be a mistake if this law was to lead to other state laws that perhaps are similar but slightly different, because then we'll wind up, as we have in some other contexts, with a wide range of divergent legislation that nobody knows how to comply with. And that's not good for anyone. That's not good for consumers. And it's certainly very difficult for industry as well, but it doesn't help the consumers. So hopefully that won't be the result.
Absolutely. As I've seen with numerous other issues, though it oftentimes seems like the finish line, the signing of something into law, oftentimes is just the starting point. So it'll be interesting to see, of course, how this plays out. Once again, that was Tanya Forsythe of InfoLaw Group. For more of her insight on this story and others in the data security and privacy arenas, be sure to visit infolawgroup.com and, of course, swing by lxbn.com if you're not already here, of course, for more of these LXBN TV video interviews and curated commentary from the Lex Blog Network's more than 8,000 members. Thank you for joining me today, Tanya.
Thank you.